I'm Lisa Park. This is my first time to be here. My family lives in Allison, or we did live in Allison, community of Decatur, Texas, and Wise County. We've been forced out of our home. I want to thank y'all for the time, for coming to listen to us. I know that's not a good seat to be in tonight. I want to address the 12-hour response time first. When we call in the early evenings, the odor and physical effects are much greater than in the mornings. However, the 12-hour response time allows TCEQ to not have to show up until in the mornings. This really needs to change. On, April 14th, I called at 6:30 in the evening. I had a dead animal, a dog that laid down and would not get up. We had nosebleeds. I had to send my family away, and y'all didn't show up until 6 o'clock the next morning. As to the fact that we can only call in when we smell an odor, my family has suffered many physical conditions, and we no longer have an adequate sense of smell. Shouldn't we be able to call when we have severe health effects? I've learned that the TCEQ is using a victim's physician statement in regards to their health condition for violations. Being that TCEQ accepted this physician statement, then they should understand the fact that an effect from exposure is the loss of sense of smell, and accept our complaint as an immediate response required. On July 25th of this year, I strongly persuade TCEQ to respond immediately, and not only did they find 6 violations, but the investigator himself became very ill on the site due to the admissions, which is clearly stated in his reports. I have a copy of that if anybody would like to see it. Are you going to call the Attorney General on these cases?
If that's a question directed to
Yes.
that particular one, I can't make that determination. We made our investigation, and I think you referred to that report there. It then goes to our enforcement division for processing. At that point, we have several different options, and those options really depend on the interaction between this agency, the facilities, their compliance history, what they've done to come into compliance, on whether or not that will be a case that will be settled and resolved with administrative penalties and technical requirements there in our enforcement division, whether it goes to our litigation division for adjudication, or whether it's referred directly to the Attorney General's office for potential shutdown and those things. So I just can't make that determination from this seat.
My family has suffered far more than any of us moms or wives should ever have to encounter. We're putting out a serious cry for help. Please help us all. We appreciate all the help that we have received, but we all need more. I understand that you would like our medical documents to prove some of these cases. It's very hard for us to step up and give information and help y'all with these situations if you're only going to give them a slap on the wrist, because that's a slap in our face. Thank you.
I'd like to address some of that. I've had the opportunity to talk to Ms. Parr this evening, so she and I have had an opportunity to talk about some of these things direct. One of the things I want to reiterate, odor is not required. It is not required that you smell odor. I tell you that if you make a call to our office, if you send us an email, if you report a complaint, and it's related to oil and gas activity, we're going to respond. The issue of the 12-hour response and sometimes responding making that determination in the middle of the night, whether to come out that night or to come the next morning. It is part for investigator safety. I will say that. The other issue is that part of the things that we're talking about is that when a complaint is lodged, we are coming out there for a specific purpose. That is to address the compliance status of that facility. And if we determine that there is an imminent substantial endangerment going on right then, we're going to try to get that company out there and try to get them involved directly in any abatement or emergency response activity that has to take place. We're not going to be able to do that ourselves. We're going to try to get them to do that. So the first thing I'm going to say is that as an agency, we're going to try to respond and come out and determine compliance as soon as practical within that 12-hour time frame. But we're going to definitely say to you guys that if in fact you are experiencing a situation that is an emergency, that I'm going to say 911 is also a number you should be calling, because we want to, our staff are going to come out there for a specific purpose. That is not going to be to address that emergency if one actually exists. We're going to be out there and we're going to have to call 911 or call that company and have the emergency staff out there. So if you're believing that's going on, call us first, but right after that, call 911, because that's who's going to address that.
Right.
But we are going to try to make sure that when we're out there that we can do something. And many times in the middle of the night with an unmanned facility, the one thing we want to determine is whether or not there's something going on right then that we need to get them out there. Otherwise, we may make that determination that we're still going to meet the 12 hours, but we're going to do it in a daytime hour where we can actually see the site. We can maneuver around that facility.
But a flare camera shows that too.
Well, again, but I want to make sure I'm being clear, because I want to make sure that I can explain to you what expectations we're playing into our staff. We do think about the staff safety. If this is a site that we've not been to before, we don't have any familiarity out there, we're concerned about our use for this. And so we want to make sure we're there within that 12-hour time frame, but we also want to add value while we're out there. So and so that goes into the decision matrix on whether or not at 7 o'clock or 8 o'clock or 10 o'clock at night we decide to come at daybreak when there's light. But if we hear things in the complaint, again, doesn't require order, but if we hear things in your complaint that says, hey, there's something going on right now that we need to be there first, one, I'm asking to ask you to call now, and we're still going to respond. But we do use those kind of things in our matrix in determining.
What do we say to 911? Please come out. I have a dead
Well,
chicken.
I guess what I'm saying is that if it's a dead chicken, I'm saying though, if there's not something out there that's apparently killing that chicken, if there is something out there that's apparently killing that chicken, yeah, I think that's what you tell them. But my
Feel like
point
an
here
idiot.
is this: is that we're going to try to get out there as soon as we possibly can, as soon as it's practical. Excuse me.
You might want to do this with 911 because they're not going to respond. I mean, people have called 911 and they said call the TCEQ.
And again, we're going to try to respond within the time practical. But what I'm saying is that there are things out there that are outside of our jurisdiction. Things that you're talking about that I would say to you that if I were in that situation, and I do have oil and gas activity in my neighborhood, if I were in that situation, I would be calling 911. Now, I may want my staff out there looking at things from an environmental standpoint to determine compliance with that facility. But if I believe emergency is going on, I'm going to call that 911 number.
Well, if it's our family that's having effects, 911 is going to tell us to go to the emergency room.
I mean, 911 is also police, it's fire. So I don't know that would be, I don't believe that would be the only thing they tell you to do is go to emergency.
Could you again tell us what the pathway is to getting to the Attorney General? Because what you said was not very clear to me, and it sounded like it's months and months away. And when you're living in your husband's office, that's an awfully long time to wait.
And I'll restate it, but I don't know if the answer will make any more sense. If there's not an imminent substantial endangerment at that time, I mean, there are activities that we have to deal with, that we address, where that activity is still going on. In this particular case, it was an activity that took place. It's now ceased. But if an activity were going on and a company could not or would not stop that activity, that referral could be immediate. And
This is a repeated.
right, and I'm saying that is the challenge in this case. If this were a continuing activity, one where that endangerment situation was going on and that company could not or would not stop that referral to the Attorney General's office to get that shutdown request would be immediate, or could be immediate. The challenge here is that issue that was that substantial endangerment has ceased. And so the process is going through our enforcement division to determine whether or not the action should be held through our litigation force or a referral to so I can't say to you that that timeframe will be the same if in fact this activity will continue.
Okay, but a pattern of substantial endangerment has been established, so does that have,
Ms. Wilson, I don't know if I can explain any different. I'll try different words, but the issue is that if it were going on, if it were continuing to go on, and that company would not or could not stop it, then we could immediately go to the Attorney General's office to get that shut down. Since that is not the case, that process, it's not happening in that process, and I don't think that we could make it happen in that process. But it would be based on the fact that that activity is continuing.
So you're saying 24/7, it has to go on 24/7 for the rest of our lives, and then we can
No, ma'am.
turn it over to the Attorney General.
When you say rest of your life, I'm saying to you that the issue between the process we're going through now is one where it's going through our normal enforcement process. And then in that process, there is that review to determine, hey, is this facility, is this company going to be a repeater and they continue to repeat this? Is this something that they are not going to fix any other way? That's the decision matrix that's going on now. And it's taking that due process. But if this were something that were going on and we determine that this is a substantial endangerment and they have not,
Sorry to interrupt, what is substantial endangerment?
that we believe that there's a life impact, that a safety issue is going on right then. The conditions that were being experienced during the investigation, the condition that Ms. Parr was talking about that she experienced, that she called us out on, we went out and confirmed. If that were continuing and they could not or would not stop that, we would then be able to engage the Attorney General to shut that facility down immediately.
So you're saying it stopped then? Then it stopped, because you didn't call, so it must have
It
stopped.
stopped. Now, and I'm not saying it stopped because we called, but it's not going on now. That endangerment situation is currently not going on.
But their doctor says that but their doctor says that they can't inhabit their house. So isn't that not still keeping them from having to peacefully enjoy their property because they have been put under doctor's, yeah.
And that's why we're pursuing that enforcement now.
So,
And so, again, I'm trying to separate the idea of when we can engage that shutdown versus our normal enforcement process. We're in that normal enforcement process now because of the violations that occurred.
okay, Christina Henry?